All right, we're going to get started. So for those of you who entered the chat later, my name is Lorena Roel, and I'm an attorney here at Brewer, Offred & Pedersen. And today I'm going to be presenting our webinar, which is entitled Holding Title to California Property, Part 1, Joint Tenants and Tenants in Common. So, as a disclaimer, hold on, I'm having a little issue with, there we go. So here's our disclaimer. It's basically saying we're not providing legal advice. It's just a informational webinar to help educate you on the topics that we're discussing. And photo of me, Lorena Roel. All right, so the basics of holding title to real property. So holding title to real property, there are 4 recognized methods. It's joint tenancy, tenancy in common, tenancy in partnership, and community property. There are little offshoots from community property, from holding title to property under community property and tenancy in common. And when we do host a webinar on those 2 topics, then I will divulge more into that. For example, you have property holding community property and then community property with right of survivorship. That's its own webinar that we will host, and same with tenancy and partnership. But those are JT, TIC, TIP, and CP are the 4 recognized methods in California. And how you can tell in which manner the property is held is based on the recorded deed. So the deed itself will say either joint tenancy, tenancy in common, tenancy in partnership, and community property. So methods for actually obtaining title. So to have title to transfer one property from one person to another, you need a deed. So the 4 main deeds are grant deeds, quitclaim deeds, warranty deeds, and deeds at judicial sale. The deed is the written instrument that conveys or transfers the title of real property from one person to another. So you have to have a deed. It is required in order to transfer property from O to A. And the most common one used in California is a grant deed. And right now we're going to be focusing in this webinar, we're going to be focusing on transferring the property via grant deed. As I've stated, there are quitclaim deeds, warranty deeds, and deeds by judicial sale. However, the focus is going to be on the grant deed because I want simplistic examples to provide when we are transferring a property from seller to buyer. So the reason why a grant deed is the most common used is because it's often the most acceptable by grantor and grantee, so seller and buyer. Side note, grantor and grantee is pretty much exchanged with seller and buyer. Grantor is the seller, grantee is the buyer. And when we're talking about holding title and the transfer of title, I might go back and forth between saying seller and buyer and grantor and grantee. So just wanted to clarify that in case there's any confusion on what I actually mean. So grantor is the seller and grantee is the buyer. So I will try to keep it unison to not cause any confusion, but just in case you are aware, they are, in my example and in this webinar, interchangeable. Okay, so the reason why grant deeds are often used, aside from the fact that they are the most widely accepted between the grantor and grantee is because it specifically states that one person is granting their interest in this property to another. And there are limited warranties that are associated with that grant deed. So in a warranty deed, the reason why some people don't want to transfer the property via warranty deed is because there's a lot of warranties that the grantor is granting over, and they don't want to be held to that. Versus a quitclaim deed, a buyer or a grantee doesn't really want a quitclaim deed because there are no warranties attached to it. A grant deed is kind of a mix between the two, where it gives some, but not all. And so the buyer's happy, the seller's happy, and everyone gets to transfer the property. And I'm not focusing on deeds at judicial sales because, again, that's its own topic. And it has its own set of procedures. So those are the 4 main deeds. And again, in this webinar, we are going to focus on the grant deed. Okay, so requirements for a deed. There are basic requirements for having a deed in the state of California. First, you have to have the name of the grantor, and they have to have the capacity to contract. So if, say, it's, grandma or grandpa, and they don't have the mental capacity to enter into contracts, well, they don't have the mental capacity to execute a grant deed. It's kind of the same notion where if you have the ability to contract, then you have the ability to execute a grant deed. If you don't have the ability to contract, you don't have the mental capacity to execute a grant deed. And there are ways around that. If you're the attorney in fact or the successor trustee, there are ways to execute a grant deed for a living person who doesn't have the capacity to contract. And so I can discuss that in a later webinar, or if there are any questions regarding that at the end, I can answer them. But whoever is executing the grant deed has to have the authority to execute it, has to have the capacity to execute it, and it must include the name of the grantor, the owner, or seller. Okay, the second is the name of the grantee. Who are you granting it to? So you have grandparent to grandchild. So name, grandpa is executing this grant deed to give the property to grandchild. And it has to actually state the name of the person. So for example, whether it's grandparent to grandchild or seller to buyer, it has to specifically state John Doe grants real property to Jane Doe. The names have to be specific. So that means that when naming the grantee, you can't just leave it open in the air, such as for all my future grandchildren or my future children or potential cousins, nieces, what have you. It has to be very specific. And they need to be able to take title to the real property. So living incapable of taking title to the real property, meaning they have to have the capacity to contract, meaning they need to be 18 years old. So those are the first 2 main requirements, which is naming the grantor and naming the grantee. So everything has to be specific. Then we come to the third, which is the description of the property. So in my example, I provided John Doe grant deeds the real property to Jane Doe. Well, it just can't say the real property. It needs to say John Doe grants 123 Rainbow Avenue to Jane Doe, legal description attached as follows. And then you have Exhibit A, which Exhibit A will be the legal description that is found in the county recorder, which lists most likely its position on a map, the book that the legal description is can be found, and any other descriptors. Some real properties have a description that's 3 lines. Others have a page or 2. It all just depends on how the property is described within the county that it's located in. Okay, and then number 4 is language indicating intent to convey the property. So back to the example, John Doe grants 123 Rainbow Avenue to Jane Doe with the attached description of the property attached to Exhibit A. So that example I provided has the grantor's name, has the grantee's name, provides a description of the property, which is the common address plus the legal description attached to Exhibit A, and then the language indicating conveyance, which is grants. John Doe grants Jane Doe. So those are just the 4 basic requirements. Each deed needs to have those in order to be a valid deed. So a non-valid deed is John Doe grants property to grandchildren and any future grandchildren. 1, there's no description of the property, and 2, there's no names. He just says grandchildren. Who are the grandchildren? Does he mean all of them? Does he mean the ones that are 18? Does he mean future ones coming about? Like, what is he trying to grant? So that's why it needs to be very clear and specific on who's the grantor, who's the grantee, the description of the property, and the language showing the intent to convey. And I've focused on this slide a little bit longer than I probably need to, only because we've had issues in the past where our documents are not being recorded. So a client will try to record their documents. It keeps getting rejected by the county recorder. They come to us and we realize it's because they're missing, one of these specific basic requirements. And usually it's the description of the property with the attachment that's not included. But aside from that, everything else is usually there. But there are issues that we've seen, so that's why I'm trying to focus on this right now. Okay. So we talked about the basic requirements of a deed, and that the deed needs to be in writing. So next in California, we have to record the deed because California is a race notice state, meaning that if one person writes a deed and provides it to the grantee, that unless the grantee records it, the property is still kind of up in the air and the grantor can sell to somebody else. And I don't mean to say can, because there are a whole lot of issues that arise from double selling. One, that it's not okay, but they have the ability to, because the new buyer will come in and see that nothing's been recorded. So they believe that they have the right to purchase this property. And they do have the right to purchase that property. It's whether or not the seller has the right to sell it. So in addition to the basic requirements of a deed, so I'm going to go back one more, you have these 4, but then there are 2 other matters that you need to do, which is delivery and acceptance. The reason why I don't have them here and the reason why it's not really an issue now is because deeds are pretty much completed with your escrow, and so they just automatically get delivered and accepted by the grantee slash buyer. So normally it would, back in the day, I would have added 2 more, say like the early 1900s. We would have name of grantor, grantee, description of property, language indicating intent to convey, and delivery of the deed and acceptance of the deed. And those are important because, for example, say a grandparent wanted to give their farm. This is a classic example that we get in law school. The grandparent wants to transfer the property to their grandchild. And so they complete a deed, has their name, has their grandchild's name, describes the property and the intent to convey. But they leave the deed in the dresser. So grandchild has no knowledge of this deed ever occurring. And because grandpa didn't deliver the deed to grandchild, the grandchild is not aware of it and so cannot accept. And so that deed's not valid, in the sense of if grandchild later on found it after grandparent died and then tried to make a claim, unfortunately their claim would fail because the deed wasn't delivered and the deed wasn't accepted. So another example, say grandpa did complete this and deliver the grant deed to grandson, and grandson realized he doesn't want a farm life and wants to move to the big city. So he says, no, grandpa, I don't want this. I don't want the land. Okay. Well, there's no acceptance. So at that point, there is no transfer. Grandfather intended for that to happen, followed the steps, and the very last step, which was acceptance, did not occur. So grandpa is now free to transfer the property to anybody else. And that is important for everyone to know, that there is delivery and acceptance, but it's just not really focused on anymore because we do use escrow agents. And it's clear that when a buyer puts down money to purchase a property, that they will accept it. And part of, the escrow process is for the sellers to execute a grant deed, which is then delivered to the buyers. And of course, it's accepted. So that's why it is not its own slide or part of this slide, because it's just something that does come around and just happens naturally, but it is a requirement. And the reason why I came back to this to discuss delivery and acceptance, is because of the following slide with regard to recording. So I gave some brief examples, but I'm going to use the grandchild farm example again for this. So we've already stated that I gave the examples of not delivery and then not acceptance. So say there is delivery and acceptance. Grandpa executes the deed with the 4 main basic requirements. He delivers the deed and grandchild accepts, and then grabs the deed and throws it in his own desk drawer or something. And for all times, therein, he believed the property was his. There was an effective transfer. They followed the requirements, so the property is his. Except grandchild didn't record that document with the county recorder. So let's say 20 years go by and somebody wants to purchase the farm, and they look at the county recorder, see that it's owned by grandpa, and go to grandpa and say, oh, I would like to purchase this farm from you. According to the county recorder, you still own it. I want to buy it. Is that okay? Grandpa, with the capacity to enter into a contract, because that is a requirement, says, okay, I thought my grandson wanted it, but it seems like he didn't. I will sell it to you, and sells it to this third party. The third party is a bona fide purchaser. They got the property legally. They purchased it from the seller, and whether the seller did something wrong, that's its own situation. But to that buyer, the buyer had no notice that the property was owned by someone else and paid money to purchase the property from the owner that they believed based on the recorded documents. So it's important because a lot of people will transfer deeds, not necessarily when you're working with an escrow agent because they have a process for you and they outline what you need to do. But some people do like to either transfer property between their family members or do it themselves because they believe that they have the knowledge for it, and will transfer the property but not necessarily have the document recorded, or will get the deed and say, oh, I'll do it next week, and they just keep pushing it back, and then we run into this problem. So race notice is extremely important because it prevents all the issues. And so what we always advise to anyone not working with an agent or escrow is to, as soon as you get that deed, go and record it. It must be recorded. It needs to be recorded today, tomorrow, as soon as possible. If you want it to be on the record, it must be recorded. Because otherwise, when you do title searches or try to go back in the county records to see who actually owns the property, you're going to get the last person because you didn't record your document. And for recording, it needs to be notarized. But if you're not recording, then the deed does not necessarily need to be notarized. So a lot of people get that confused because it's just automatic. When you're preparing a grant deed or any type of deed, you have it notarized right then and there, but that's with the intention to go and record it. And you know the document needs to be notarized to be recorded. If you are executing a deed without it being notarized, be very cautious, because why is the intent not to record it? You always want anything regarding real property to be recorded. For it to be recorded, you need to be notarized. So if there's any document that you are executing and you are concerned that it's not being notarized, definitely speak with someone regarding the concerns, because it is very weary to me that someone would execute a grant deed or any type of deed and then not get it recorded. So just in case. All right. So lastly is title insurance. So I talked about this a little bit at the very beginning when I was talking about grant deeds. But let's just focus on it right now. So title insurance is available throughout the state. It basically is telling the buyer, hey, I have the correct title to be able to sell this to you. So buyer isn't going up to some stranger who's standing near the property and saying, oh, I'll pay you X amount of money for this property. And that stranger says, sure, takes the money and then walks away. And they actually didn't have the right to sell the property. Title insurance allows for you to do that. Title insurance allows the buyer to know that they are buying the property from the correct party. It's available throughout the state. It's very easy to get. Pretty much, you're always going to get it. There are instances where you might not, but it's about 98% going to happen. So that's why I'm briefly touching upon it. Because it's technically not legally required to get, especially say you know that the property's been in the Hanson family since the 1800s, and Joe Hansen is selling it to you. If you guys are doing it without agents, trying to do it without escrow because you have the money, then okay, you technically don't have to have title insurance. You do need to have a notarized grant deed that's recorded to prove to, everybody that you are now the record title owner of the property. But you don't technically need title insurance. However, if you are going to get a loan on the property, most likely it's required by your lender because your lender, the bank, wants to make sure that who you are purchasing the property from is the correct owner because they don't want to give you money when they don't want to give you, the buyer, money when you are potentially purchasing the property from someone who's not the owner, like the stranger in the previous example. And quick touch upon loans. You can have parties on title to the property that are not on the loan, and vice versa. The main times I see this situation occurring is when you have parents who are assisting their child with the purchase of their first property. The child can't qualify by themselves because it is their first home. So the parents and the child usually enter into a loan for the property. So the deed of trust is for the property that's purchased, but the property is in the name of the child itself. However, all three, the child and the parents, are on the loan. It's important for people to know that because it has been happening. And there are issues with that occurring. I haven't seen any as of yet being extremely negative where I would advise against it. It is a tactic for parents to assist their children. It's a tactic for people, especially younger generations, to be able to even get a loan on property because of student loans, other debts, and just the cost of living. It is pretty difficult to not have that credit enough for banks to want to loan to you. And especially if you don't qualify or you want to get a better deal than a first-time home buyer's loan, then you use this method. And that's perfectly fine. If there are questions on loans specifically and or title insurance at the end of this, what I would do is take your questions and then speak with a title insurance officer and a loan officer and answer those questions in part 2. Because for those issues, I do know enough to guide, but if they're very specific and technical, I would like to speak with someone who's working in that field to have a better understanding and to be able to provide a better response to your questions. Okay. So I said this earlier, but I just want to repeat that this presentation is only covering joint tenants and tenants in common. As I previously said, there are four recognized ways to hold property in California: JT, TIC, TIP, which is tenancy and partnership, and CP, which is community property. My next webinar is going to cover holding title to property as spouses, so community property. And that will also discuss community property with right of survivorship. And I do believe I'm going to touch upon transferring property from JT or TIC to community property and use examples like, a couple purchasing a property with their separate property in JT or TIC, and then getting married several years later, and then wanting to transfer that property, or at least their separate property interest in it, to community property, since they purchased it while they were together, they got married, and they just felt like, let's do that. So that will be the next webinar. We'll be focused solely on community partnership. Okay, so tenants in common, or what I've been saying, TIC. That's going to be our first topic. Okay, and tenants in common. This is the kind of universal default. If your deed does not specify how the property is to be held, well, it's going to be held in tenants in common. This occurs when you have two or more people who are going to be the owners of this property, whether they be friends, siblings, a couple, unmarried couple, for my example, to keep things easier. If it's two or more people, then it's going to be tenants in common unless specified otherwise. This tenants in common is created by a grant deed, express or implied. As I said, it's implied if it's not specific as to what type of method you intend to hold the property. It will default to tenants in common. Or your grant deed can be express. So let's say Harry Smith grants to Jane Doe and Wendy Doe. If that's just what it says, and I am implying that everybody has the capacity to enter into a contract and that the real property description is in the deed. I'm just trying to make it shorter. So just for your information on why I'm not doing an extremely long grant deed explanation. So Harry Smith grants to Jane Doe and Wendy Doe. If we just leave it at that, defaults tenants in common. Or it can be Harry Smith grants to Jane Doe and Wendy Doe as tenants in common, which is express. And then we have the percentage of ownership. And that, again, is express or implied. So we have our example of Harry Smith granting to Jane Doe and Wendy Doe as tenants in common. If there's nothing about percentages, then it's default to 50%. Harry Smith grants to Jane Doe and Wendy Doe. Again, implied that it's tenants in common, and again, implied that it's 50% because there was no distinct or express know about the percentage of ownership. So if you want it to be something other than 50%, then it needs to be expressed. Say Wendy, in our example, Wendy Doe put down, 60% of the down payment, and Jane Doe only put down 40. Well, they can have the deed specifically say, Harry Smith grants to Jane Doe a 40% interest and Wendy Doe a 60% interest as tenants in common, or just in their interest, which again defaults to tenants in common. So that is a way to really reflect the express percentage of ownership if you want it to match the monies put down for the purchase of the property. It is not common for people to do that. People don't really do that. You'll have Wendy who puts in about 70%, Jane who puts in about 30%, and they just say grants to Jane Doe and Wendy Doe, and they just leave it like that. And then you have the implied tenants in common, and then you have the implied equal percentage of ownership. This becomes an issue when things go sour and somebody who's been paying more all along or who paid more at the beginning wants their money back. So say Jane and Wendy got into a huge fight at whatever family dinner that they were at. And so now they're not talking to each other and the family can't bring them back together. So this happens a lot with siblings. When siblings paying more and they get into a fight around Christmas or the holiday season, and it comes up, and now we have to try to resolve it. Either partition the action, partition the real property, which I'll discuss later, or try to come up with some resolution. So if you don't intend to have the property be equal ownership, 50-50, then put down the express percentage of each person's ownership. That is key, I believe, in being exceptionally clear of, who's more responsible for the monies going in and out of the property, who pretty much owes more money. Person with the greater interest will owe more. It's not going to be 50-50 division. And I think it's really key to resolving a lot of the issues, especially because it seems that most of the problems that we have with tenants in common goes back to the very beginning when Wendy put down 70% or 60% or anything more than 50 towards the purchase of the property. A fight ensues, and then that is where everything goes with regards to problems. It all traces back to that one issue. So I highly suggest to put an express percent ownership if there's a difference in monies used to purchase the property. Okay. Let's see. Oh, actually, let me go back real quick. So in addition to interest, the percentage of ownership, I also want to talk about possession. Apologies for moving on too quickly. You have Jane and Wendy, they either own it 50-50 or 60-40, 70-30, however you want to have it. Regardless of their ownership, each of them has the right to possess their property. And possession can either mean physical possession or just the right to enter and know what's going on. I mean, there's a difference if, say, Jane's living in the property, Wendy can't just come in all the time unless they have an agreement that she can. But that's not what I mean. And it doesn't mean 50% or 40%, 30, what have you, in which you have the property and then you draw a line down the middle and Jane can only use this amount and Wendy can only use this amount. That's not how it goes. It's just the right of possession. Since your name is on the deed, you have the right to the property and the right to possession of the property. And if one party tries to prevent you from such possession, that's considered an ouster, which is not great and not advised. Even if you guys are fighting, do not try to kick the other one out. It will make things a lot worse, not only for any other reason besides you have this now other legal matter that you're trying to resolve. So even if you are having issues with your other tenant in common, do not oust them. Just wanted to touch upon that before I move on to joint tenants. So joint tenants is the next. And joint tenancy is different than tenancy in common with regard to how it's held. Obviously, it's a different type, but it's mainly related to the percentage of ownership. In TIC, you can have equal ownership or you can have different percentages. In joint tenancy, you can't. They must be equal, identical, and coextensive, meaning it's 50-50, or it's split between 3 ways or 4 ways. There is no instance in which one tenant in common can have a higher interest. There's no instance in which a joint tenant can have a higher interest in the property than the other. They have to be exactly equal. And in a joint tenancy, it has to be express terms. So like I said with TICs, they are kind of the default. So if nothing is expressly written and it's implied, it automatically goes to TIC. In joint tenancy, there needs to be an express declaration with explicit language that the parties want to be holding the property as joint tenants. So, for example, Harry Smith grants to Jane Doe and Wendy Doe. What is that? That is a tenants in common. Harry Smith grants to Jane Doe and Wendy Doe as joint tenants. That is joint tenants because it's an express declaration with explicit language that they want the property to be held as joint tenants. Okay, last one. Harry grants to Jane Doe and Wendy Doe, or let me start that over. Harry Smith grants to Jane Doe a 30% interest and Wendy Doe a 70% interest as joint tenants. Last one was to be a trick. I don't know if it worked, but that can't happen because, again, joint tenants have to be 50-50, or if it's not 50-50, equal ownership. So there cannot be different in changes. So that grant deed, the last one that I just provided, doesn't work out. It'll either knock out the percentages and be joint tenants, but probably not. If anything, it will, when we review it, or if I were to review something like that, I would say, well, you put the percentage of ownership in there for a reason, because you wanted that to be reflected, which means that it's not joint tenants. So I probably X out the joint tenants and say what you guys intended was for tenancy in common with a different percentage of ownership. And that's most likely what would happen. So the reason for that is because, again, not equal ownership. And that's why, at least for joint tenants, we have 4 unities: interest, title, time, and possession. So your interest is equal interest. Your title is as joint tenants. The time is you guys are, preparing this at the same time. And possession is equal to that of the tenancy in common, in which you intend to take possession of the property. Not necessarily physically, but you intend to possess the property. It will be one of your possessions and items that you own. Okay, and for creating a joint tenancy, there are instances that I've seen in which people, fearing that their deed, which specifically says Jane Doe and Wendy Doe as joint tenants, is not sufficient enough to be an express declaration or explicit enough language to convey that they want a JT. They add a bunch of other language so that everything else is going to be created 50-50 with regard to rents or anything else. So people will add more language to clarify that their intent is to create a joint tenancy, but that is not necessary. It's considered surplusage, and it doesn't help the problem. It's just, oh, that's extra language. So just be clear with as joint tenants or joint tenancy or things like that. Okay, rights and differences between joint tenants and tenants in common. And this is the main reason why people will pick a joint tenant or over tenancy in common or vice versa. So joint tenants, you own the property together, except when one person dies, their estate does not take over control of their percentage interest. Upon their death, their interest in the property essentially goes poof and just automatically gets absorbed into the survivor. So, example, Jane Doe and Wendy Doe on the property as tenants as joint tenants. Jane passes, and upon her death, her interest in the property goes poof. Wendy then owns 100% of the property. People do this in order to avoid probate, or they don't want to prepare a will or a trust or anything. They just think that it's easier, and it kind of is, because the property is not owned by their estate, so there's nothing to dispose of. The property just automatically goes to the survivor. So that's joint tenancy with regard to survivorship. And people choose that, again, to avoid the probate process and trust process and all of that. But if you actually want to have your interest go to somebody, whether it be the person that you own the property with, or a child, a niece, a nephew, or somebody else, then you're going to want tenants in common. So that means that Jane and Wendy own it as tenants in common. Jane dies. If she dies intestate, then her estate will need to probate to start the probate process. Whether it be a small estate affidavit or regular probate with filing a petition with the courts, and try to do something with her interest. Wendy still owns her 50% interest in the property as herself because she's still alive. But Jane's estate owns her 50% interest. And with intestacy, we got to go through the probate process. With the will, still go through the probate process. With trust, most likely connected with the will, still going with not necessarily the probate process, but a process for the distribution. And then however Jane has disposed of her interest in this property, whether it be to Wendy or to Jane's own children or family or friends, that's up to Jane. But she has the right to dispose of her property whichever way she feels like, because it's hers even upon her death, unlike in joint tenancy where it's not hers upon her death. So it depends on what you want. There are, for example, people choose joint tenancy because they're a couple and they are not yet married, but they don't want to have to deal with the probate process because technically they are legal strangers since they are not married or in a domestic partnership. So in order for the survivor to get the entire property upon their death, couples go into joint tenancy. Or siblings, I've noticed that as well. Siblings do that, so then they don't have to go through the probate process as well. And tenants in common with couples who are fine with, who already have a will, trust, or are fine with intestate and they just want their interest to go to a family member, that's normal as well. Same with siblings. There is no commonality in which like, oh, these people, pick joint tenancy or these people pick tenancy in common. It's just where you are at the stage in your life, what you're looking for, and if you want to have the other party have to deal with probate or not. That's really it. And I'm trying to think, there was another matter in which people would choose. What I've seen with tenants in common is that the survivor usually purchases the decedent's interest from the estate. So so Jane dies. We're going back to my example. Jane and Wendy hold the property as tenants in common, equal ownership. Jane dies. Her trust says that her interest goes to her daughter. Her daughter really doesn't want anything to do with the property, either lives out of state or has her own or number of reasons. Jane's daughter does not want the property. So Wendy will say, hey, I'll purchase your 50% interest. And that's kind of what is very common, that the survivor purchases the interest from the estate. It's easier, and it prevents having to deal with a partition action. In case there is a dispute and they try to sell the property, the estate does. And it keeps the person who's surviving, who's already living there, or who still just owns and manages it from having to do much else. They just purchase. That's not always the case. And just because they do purchase doesn't mean there won't be any other problems. I'm just stating that that was very common to see. So, rights of the tenants. So for both joint tenants and tenants in common, they are tenants with each other. And co-tenants have a right without consent or approval of the other to sell, encumber, or take possession of their interest. So Jane Doe and Wendy Doe. Jane Doe is hit by hard times, wants to sell her interest to someone, anybody, because she just rather have the cash than an interest in the property. Wendy can either purchase Jane's interest and own the property herself, or Jane can sell it to another. Jane has the right to do so. She doesn't have to ask Wendy, though it would be nice. She doesn't have to. Same with taking a loan out on her interest on the property. So again, if Jane's on hard times and wants a loan, she can ask the bank to provide a loan based on Jane's 50% ownership interest in the property, whether it is tenants in common or joint tenancy. It doesn't really matter. She has a 50% interest. She can encumber her interest. And that's also with regard to taking physical possession. It's subject to the equal rights of somebody else. So, and by somebody else, I mean the other tenant. So, say, same example, Jane's on hard times. Wendy's living in the property. Jane says, hey, I want to move in. I need a place to stay. I own 50% of this. Wendy can't say no. Well, she can't say no, but that would be an ouster. So in this instance, Wendy says, sure, come along. And so Jane moves in. But that doesn't mean that Jane has the right to then kick Wendy out, because that would be the equivalent of Wendy saying, no, you can't come in. They have the right to possess the property, and as long as they just don't really, try to take exclusive possession or affect the other party's interest, it's fine. And again, if they're both living there, it doesn't mean that they have to split the kitchen down the middle or anything else down the middle. They just live in there like roommates. When it regards regarding the community property, it's the common property. Co-tenants cannot enter into certain contracts, such as easements, servitude, or removal of timber or materials. So Jane and Wendy own the property, regardless of if they live there or don't. Jane can't go to a corporation, say, go ahead and mine the timber on our property, or go ahead and mine the minerals on our property, without Wendy's acceptance. That's the same with creating an easement. When it regards the entirety of the property and how it's run, then you need both. When it's just talking about your interest, then that's something else. That's why when it regards to the tenant's interest, they are allowed to do certain items. When it regards the entire property, they are not. They need consent of all parties. Okay. So now we have the income. So for both joint tenants and tenants in common, when it's occupied by the co-tenant themselves, there needs to be a contract concerning the division of income. So say, okay, Jane and Wendy own a property, regardless, tenants in common or JT, they own a property. Wendy's living there and ranching on the property. Well, there's obviously income coming in from her work. Jane, who is not doing anything for such work or labor, isn't entitled to the income of that company, Wendy's ranching company, unless there is a agreement. So Jane and Wendy agree that Wendy is going to ranch the land, and Jane will get a 2% interest of the net profits over the course of the fiscal year. Okay, then that gives Jane the right to have income coming from their property based on the labor and maintenance done by Wendy. But if that's not it, it's just Jane doesn't want to live on the ranch and Wendy does and wants to ranch it, and she does so, then Wendy gets to keep all of the income based on her labor and management of the property that produced such revenue. And a lot of the reasons why I've been using farm and ranch examples is because it's easier when it comes to at least division of income. And those are the easier examples, especially when it comes to the deed being in the drawer. And so there's no particular reason why I am choosing ranch and or farm-based examples. It's not that we exclusively only work with those. We work on regular residential properties and commercial properties. But that's just the way I've chosen to provide examples today. Okay, so if the property is occupied by a third party, Jane and Wendy own the property. Neither of them want a ranch. They want to live in the city, so they lease it to a rancher. The rancher, does his business, and there's an income from that. And so, based on the rents that he's paying for the ranch, Jane and Wendy each get 50%, unless they decide to split it in a different manner. But they each get an interest of the income that from the property when it's, leased out to a third person. If we're going more into the depths of whether the rancher only, provides regular rent and then an income based on the amount of profits they received from the business, that is a contract that needs to be drafted for each and every individual situation. It's not automatic. It's automatic just that tenants who own the property and lease it out to a third person, they have the rights to a equal division of the rental income unless they agree differently. Okay, so I see that we're a little over an hour, so I'm going to try to move a little bit quickly. Okay, so again, for both of them, this next slide, we have the pop-up of the pink box, which is just restating that absent an agreement. This one is to highlight that if there's no agreement and one of the tenants is managing the property and the other one isn't, that tenant just doesn't automatically get property manager's fees or anything like that some people feel that they are entitled to, especially when a fight ensues. It's just if they are maintaining the property because that's what they want to do, great. If they want to be compensated for that, they need to have an express agreement with the other tenant in which that tenant says, yes, you shall get paid for your efforts in maintaining. If they don't, then if there is no agreement, then they're most likely not entitled to that. You can always make an argument, but put it in writing. Okay, so reimbursements. Let's see. All right, I'm gonna try to get through this real quick. Okay, reimbursements. In a true joint tenancy, you are not entitled to reimbursement absent an express agreement. So joint tenants is from the beginning, you are taking the property as equal ownership. There is no distinction between whether somebody is 30% owner, 70% owner. It's equal. So everything's equal. You entitled this to be your property, and regardless of the monies that you put in, if you always put in 100% and the other partner puts in 0, or it's just slightly different where it's 60-40, it doesn't matter. You guys intended this property to be owned by you equally, and so it shall be. And the intent is for the benefit of the two parties. So you're not trying to get reimbursed because you own it equally. This is to be yours. To fight that matter, say one party does end up paying 100% of or 90%, and the other party pays 0 to 10% of the costs associated with the property, you can always rebut the joint tenancy presumption. That in and of itself is just arguing, saying that we did put joint tenancy on the deed. We didn't really mean to do that. There is an agreement that I am to be reimbursed. It's basically fighting the joint tenancy so that you can be reimbursed even though the property is held as joint tenants. This is pretty difficult because you have to have a lot more than just he said, she said. You need hopefully an expressed written agreement, which unfortunately doesn't really happen, but that's what we would like. And if there isn't, then at least some consistency in how the parties behave with each other. Are there text messages, emails, something where there was a common understanding that so-and-so, that Jane was going to be reimbursed or Wendy was going to be reimbursed. If there isn't, then that's an uphill battle to fight for reimbursement because the court might find it to be a true joint tenancy. Now there's a difference in tenants in common. So you are entitled to a credit from the other tenants based on your and their ownership interest. So if it's 50-50 ownership, then if you paid $100 in taxes, in property taxes, then the other person needs to reimburse you $50. dollars. But say Jane Doe and Wendy Doe, Jane owns only 30%, and Wendy owns 70%, and Wendy paid the property taxes. Well, Wendy can only be reimbursed 30%, not 50%, because Jane only owns 50%. Wendy is not going to be reimbursed more than what she should, because if she has a greater ownership interest in the property, then she's expected to pay up to that ownership interest. So everything else will be divided that way, which is 30-70. So that means Jane only needs to reimburse Wendy 30%. If it's 50-50, again, then everything's just split equally. Okay, so changing between tenants in common and joint tenancy, that can happen. We have it where people enter into a joint tenancy, realize that that's not really what they want, or several years later, they realize that they would like to leave their interest to whoever, family, friend, what have you. So the parties come in together, or just if we're doing a joint tenancy, just the one party, and they execute a deed to transfer their interest from JT to TAC, which then severs the joint tenancy relationship. For example, we have Jane Doe and Wendy Doe. They took the property as tenants, as joint tenants. Jane realizes she wants to leave her 50% interest to her daughter. Jane goes to an attorney, gets a grant deed that transfers from herself as a joint tenant to herself. Well, that severs the joint tenancy. So then the property is held as tenants in common between both parties. In a joint tenancy, one party has the right to do that, which is sever the joint tenancy, because it's their ownership interest that they're changing. So let's do an example with Jane Doe, Wendy Doe, and their brother Bob Doe. They all took the property as joint tenants. Years on down the road, Jane would like to leave her interest, her 1/3 interest, to her daughter. So Jane went to an attorney, got a grant deed that transferred from herself as JT to herself as TAC, and recorded it. Always record it. So that means the property is held by the three parties, Bob, Wendy, and Jane. Jane has a 1/3 tenants in common interest with Bob and Wendy, who together are in joint tenancy. But with regard to Jane, they are tenants in common. So that means that if either Bob or Wendy dies, whoever dies, their interest poofs. It gets absorbed by the surviving JT. And then whoever survives that is in tenants in common with Jane. So that's how to split a JT to TIC with remaining JT involved if you have more than two parties. If you have two parties, it just severs it automatically. Now, say you took the property as TIC and you want to move it to JT, both parties have to come together and execute a document that says that they are transferring their interest from tenants in common to joint tenancy. We have to have the 4 unities involved, which is time, title, possession, and express declaration. Let me just double check. Interest, title, time, and possession. So interest is equal interest. We have the title. They're executing at the same time, and it's regarding possession of the property. So in that instance, you can't have Jane and Wendy, who are in tenants in common, and Jane comes in to her attorney and says, I want to transfer the property into joint tenancy. You can't do that. You need both parties involved. But you can, if you, we'll go back to the example with Jane, Wendy, and Bob. Jane, Wendy, and Bob are in tenants in common. Wendy and Bob decided they want to be in joint tenants. Jane does not want to. So Wendy and Bob go to an attorney, say they want to transfer their interest together in this property to joint tenancy. So once that's done and the deed's recorded, the property will be held in 1/3 interest. Tenants, Jane will be 1/3 tenant in common with Wendy and Bob, who are joint tenants with each other, each with a 1/3 interest, and who are tenants in common with Jane. So you are able to go back and forth. It's just, does the deed match the exact requirements that need to be met prior to it being recorded and then it being recorded? Okay. Oh, yes, I should have flipped over to that slide. Okay, so now the real reason that actually brought me to this topic. As I've said, we had a lot of issues coming up with JTs and TICs coming in and either transferring the property out, not truly understanding what it was meant when they entered into it 5, 10, 15 years ago. And they're now trying to kind of resolve a matter because a fight ensued and either the couple splitting up or the siblings aren't talking with each other, or one party needs the money and the other party doesn't, whatever, what have you. It's just, we have disputes over title now because over the years, one party has been paying more or claiming to have paid more, and they want to be reimbursed. So the disputes, there's not one more than the other. It's not like we get more disputes regarding joint tenancy versus tenants in common. It's just disputes arise. When you have a dispute over ownership interest, that is basically boiling down to money. So you have a JT in which technically everything's supposed to be equal and each party puts in their amount, and it doesn't matter that one party paid less or more. It's just, it's supposed to be equal. But then over the years, one party is starting to feel stressed out that they've always been paying more, and they decided that they want a higher interest. So that's when that party needs to do the rebut of presumption of tenancy, joint tenancy. With regards to tenants in common, you have two tenants in common, either 50%, most of the time it's 50% ownership interest, but one party has been paying more. So they then feel that they want a higher interest because they have been paying more. So what our job is to do is kind of evaluate what has transpired over the years, what the intent of the parties were, and the payments and proof of payment, whether it be bank statements, credit card statements, if you're trying to get reimbursed for renovations to the property, statements from your contractors, copies of checks, things like that. So we look over everything. And then most likely what we try to do before a partition action occurs is resolve it, because the partition action is going to do exactly what we do here, which is evaluate what has transpired. First evaluate when you guys took property, whether it's JT or TIC. Evaluate the monies that have gone in. Determine whether it's appropriate for reimbursement, such as a TIC, or non-reimbursement, JT, and with that presumption, rebut the presumption of joint tenancy if necessary. And then how to resolve it. Usually it's just throwing money here and there. Or if one party doesn't have the money and they just still want to be part of the owner of the property, they might say, all right, don't put me as a 50% owner. I've only been paying 20% of the items on this property, so let's rechange the deed to alter our interest. That's pretty much what's been going on, not necessarily changing the deed to ownership interest, but making a demand for repayment to resolve whatever dispute there is. Now, if that doesn't get resolved because parties want more information or it's just too soon or whatever, then you have a partition action. A partition action is basically one tenant going to the court and saying, hey, I want to do something about this. I either want to sell the property, I want reimbursement, or I want my interest in the property to be higher than the other person. So I need you, court, to help me out. And what the court's going to do is first they're going to look at your ownership interest and see if you guys are 50-50, 70-30, 60-40, however. And first it'll determine, okay, this is how you guys each own the property. Next, courts prefer distribution in kind, but if necessary by sell, then they will move to sell the property. And after all of the fees are taken out by the sell, then the remaining balance or the net proceeds will be distributed according to each party's interest. And that will also follow with reimbursement. If one side paid more than the other, then they will be reimbursed from the sale and then, the distribution of whatever else. But that is all based on what the court's decision. We try to, it's inevitable that partition actions do happen, but we try to resolve them prior to, because you have the choice in that matter. When you let a partition action happen, then the court gets involved, and sometimes it's necessary. If a party is not really willing to work with you, or if they're MIA, or it doesn't really matter. But when you do it yourself, you can at least control what's happening. Once you get into a partition action, then the court takes over and it's their decisions. So we try to resolve them prior to the need for filing a partition action, but sometimes that's just what happens. And I've been seeing that a lot lately, which is the reason why I wanted to do a joint tenant and tenant in common webinar, so that people are more informed about the similarities and differences of the two, and so that they know what they mean when they enter into or when they execute, or when they take title to the property. Not enter into, not execute, apologies. When people know when they do the escrow instructions, what should they say? Do they want it TIC or do they want it JT? What is their interest? What do they want? And how do they want this to move forward in their lives? And what does it mean? Especially if one party is not as financially secure as the other, is there going to be growing animosity? If there is, let's keep it to TIC. If we are, equal and we're fine with paying everything equally and we don't want to deal with probate, then JT might be the best way to move forward. So that's the reason why I chose this topic for the webinar, and why our next topic will be focused on community property, because one, parties take JT and TIC and sometimes want to transfer it to CP. And then what happens just in community property? Why is there community property? Why is there community property with right of survivorship? What's the difference? Why don't couples just take it as JT? So those are the types of things I'm going to talk about in the next one. And if you do have any specific questions that you want answered within the next webinar, or at least to be discussed regarding community property, please feel free to send me an email and let me know what question you have regarding the community property topic, and I will try to incorporate that into one of our sites. So we have 2 questions. Hit the wrong button. Okay. So question 1, it's tax related. So with all tax related questions, I'm always going to say I'm not a tax professional, so I would double check this with your tax preparer to make sure that the desired outcome that you want works. Because we draft the documents, but if there are specific tax-related questions, we want you to double check. So this question is, if an owner is taken off a tenants in common property, is there a way to avoid an increase in property taxes? Okay, so this question leads to reassessment. So we have Jane Doe and Wendy Doe got the property, let's say in the 90s for like $100,000. So they own the property today, 2019, and they held it in tenants in common. So at this point, Jane wants to sell her interest. Well, if she sells her interest to Wendy, then that 50% interest might be reassessed to the current value of 2019. But that would just be Jane's 50% interest. Wendy's original 50% interest will stay the same. And that's the same if Jane sells it to somebody else. So let's give an example that Jane died in tenants in common and bequeathed her interest to her daughter. So then you have your parent-child exclusion. So then Wendy's child would come in to a tenants in common with Wendy, but the assessment should not take, there should not be a reassessment because of the exclusion. That sometimes falls through the cracks because people don't realize that, or they don't file the appropriate paperwork in the right time. So when you are looking for an exclusion, definitely speak with an attorney or someone at the county recorder's office regarding, what is an exclusion, because there are potential ways to not have Jane's 50% interest increased. And same with if she were to sell it to Wendy, her sister. We can do some research to see what we can do regarding reassessment of that 50% interest. Okay, so question number 2 is it common for a lender to object to buyer holding titles STAC with an uneven split? What would a workaround for that be? Okay. Is it common for a lender to object to providing a loan to 2 buyers in TIC with an uneven split? I have not seen that myself. Usually the lender just cares about, one, do you qualify for the loan? 2, can I secure it by a property? 3, are all parties either on the loan or that's named on the property? Are they aware of them? And who it, who is the loan attached to and how is it attached to the property? So Jane and Wendy, they purchased the property and they got a loan together. Jane owns the property 40%, Wendy owns the property 60%. Does the lender care? It kind of depends. There's no one correct answer because it all depends on the bank that you're using, but the bank might not care. They just are taking a loan. Both Jane and Wendy are on the loan. The loan is secured by the property, and that's all that really matters. And that's how there are instances in which a property is held by the child, but the child and the 2 parents are on the loan. And that's okay with certain banks because all the banks care about is, can we attach this to something that if they stop payment, we can foreclose on? So it's not a clear yes, it's not a clear no. It depends because it's for each and every bank. that you go to, your credit, and how you plan on doing it. But I have not seen anything be a problem. Okay, question number 3 is, will quiet title help reacquire the property when the trustee signed over the house to beneficiary before the beneficiary compensated the trust? So I am a bit confused on that question, mainly because, are you talking about a deed of trust and that's the trustee or beneficiary, or are you talking about like a family trust, like the Harry and Wendy Smith family trust? Quiet title is used when you are trying to, assert an interest or state that somebody else has attempted to take your interest, and you are reestablishing, no, court, please tell the world that I am the 100% owner of this property, or 50% owner. So with how the question's worded with regards to trustee and or beneficiary, I am a bit confused by that. So whoever asked that question, if you do want to send me a follow-up email clarifying, we can talk about that, and I can again answer it in the next webinar. But unfortunately, I'm not really sure. Okay, actually, I got a response saying that it's a family trust. Okay, so if an owner is taken off a tenant's common property, reading wrong one. With quiet title help reacquire the property when the trustee signed over the house to the beneficiary before the beneficiary compensated the trust. Okay, so usually in trust matters, the beneficiary isn't compensating the trust. So Harry and Wendy Smith family trust, they have their kids. They named one kid a successor trustee when both of them die. They've died, and the trust now owns X amount. Whether that includes 3 properties, 1 property, money, cars, whatever, jewelry, the trust then owns that, and it's the successor trustee's duty to distribute the trust proceeds, to distribute distressed assets in accordance with the terms of the trust. So if the terms of the trust said, child 1 gets the house, then the successor trustee needs to distribute the trust in that manner and provide the beneficiary with the house, as that's following the terms of trust. If you believe the successor trustee is not acting in accordance with the trust, or is violating their duties established under the probate code, then what I would do is speak with a trust attorney specifically who does trust litigation, so that they're aware, because they're the ones who have brought petitions to remove trustees or to get more information from the trustee regarding their duties that they need to abide by. That's not only part of the trust document, but is under the probate code. And so quiet title might be a method in which to reverse a matter, but if the trustee was acting in accordance with the trust document by distributing the property to the beneficiary, then they were doing what they were supposed to, so that argument might not work. And so if anything, I would speak with a trusted attorney who specializes in litigation regarding the specific facts that you have, to see if quiet title is the right method to resolve the matter, or if it's better to bring an action to remove the trustee. Okay, so it seems like that is everything that we have now. So I'm actually going to sign off. I hope everyone learned a little bit something or enjoyed the webinar. And again, the next webinar is going to be about community property. So if you have any questions, please feel free to email me and I will forward them to our marketing director, Clayton, so that we can, start moving forward with our next webinar and preparing and seeing if we can get those specific matters addressed. Okay, have a great Tuesday, everybody. Thanks.